Well, good morning. Welcome to our webinar today, Healthcare and Life Sciences in Russia, supported by Leidings Law Firm. We're going to be hearing from two of the partners at Leidings today, and two external experts. I'll get them to introduce themselves in just a moment, but obviously hugely topical and timely debate. My name is James Wood. I'm one of the editors at the Legal 500. I'll ask perhaps first Dr. Christopher Bruckner, one of our external speakers, to just give a brief introduction. So Christopher, can you tell the audience who you are? Sorry, Christopher, can you briefly introduce yourself for the audience, so those of them who may not know who you are?
Yeah, of course. Now?
Yes, please, yeah.
Okay, yeah. Okay, my name is Christopher Bruckner. I'm a pharmacist and patent attorney, European and German patent attorney. And I'm working with Dennemeyer Associates here in Munich, in Germany. Dennemeyer is a worldwide service provider and law firm for all and everything in patents, trademarks, and so on. And since I'm a pharmacist, I'm specialized in pharmaceutical things and chemical things. And so, yeah.
Excellent, and I gather we'll be hearing some of your views on the Sputnik vaccine.
Yeah.
Excellent. Thank you very much for joining us. Okay, great. Next, I will ask Andrei Filippov to introduce himself, please, from Roche in Moscow. So, Andrei, could you tell the audience who you are, please?
Yeah. Hello, everyone. My role is legal and compliance business partner within the Russian and Moscow Roche affiliate. I basically support business processes within the company with the special focus on the specialty care business unit, and also is involved in developing of personalized healthcare processes and legal matters that relates to this topic.
Excellent, thank you very much. And from Leidings, we'll be hearing from Boris Malakhov. Boris, would you give us an introduction, please?
Oh, yeah. Hi, everyone. My name is Boris Malakhov. I'm a partner at Leidings. I'm working with every and each aspect of intellectual property. I'm a patent attorney. I'm an attorney at law. So that makes you probably think that I'm doing much court work, and it's indeed so. And today I will be speaking about the various aspects of IP protection in the sphere of life sciences, and those, highlighted issues of the never-ending battle between generics and originators, and how the landscape changes the way the business is doing in Russia. Thank you.
Thank you very much, Boris. And last but not least, we'll be hearing from today and seeing the moderation of Andrei Zelenin, the managing partner and the head of the pharmaceuticals and healthcare industry practice at Leidings. So, Andrei, please, can you give us all a brief introduction? I'm sure everyone knows who you are, but...
Thanks a lot, James. Yeah, I'm Andrei Zelenin. I'm managing partner at Leidings Law Firm, Moscow, Russia. I'm heading the pharmaceutical and healthcare industry practice at the firm, which is one of the strongest life sciences and healthcare practices in Russia. We are very glad and thankful that Legal 500 has been organizing this event for everyone today. And of course, we're welcoming the attendees who are joining us virtually and looking forward to an active discussion, both among the distinguished panelists here and with the audience. James, I think you give some technicalities on how the questions can be asked, and then we go to the substantial topics, correct?
Yes, yeah, sure. Look, thank you all for those of you joining us in the audience. If you do have any questions or comments on the topics we're discussing today, could you please use either the Q&A or the chat function at the bottom of your screen to ask questions. We won't be enabling cameras for those of you in the audience, but please put a name to a question, address it to one of our speakers, and we'll answer it as and when it comes in. Okay, great. Well, that's all from me, really. We'll be running for an hour. This obviously is being recorded, so it will be up on the website. But Andrei, do you want to give us an overview of the topic?
Sure, and I would probably start with a few words about the firm, some recognition slide that showcases our recent awards and rankings on the particular topic or subject area that we're discussing today, just to make the audience sure that I will not exaggerating when saying that we're leading practice in life sciences and healthcare. Again, a welcome slide about Leadings, which is a Russian law firm, strong in advising local and multinational pharma and healthcare on all key aspects of doing business in Russia and CIS. We have a team of 25 plus multilingual lawyers here. We have also established a strong and successful collaboration with other firms abroad. And Christopher here is an evidence of that collaboration. We're quite thankful to Christopher that he's been able to join us today. Not to delay the intros more, probably we need to give a chance to the audience to introduce themselves. And here is a slide with a poll that I hope James would now be able to switch on via the Zoom facilities. Please let us know what group do you belong to. Are you an in-house counsel in a pharma company? Are you holding a non-legal role in a pharma company? Maybe you're a private practice lawyer, or you're none of the above and just interested in life sciences, and that's why you have joined.
Okay, so the poll should be live on your screen now, so you can all vote and see it coming in real time.
Yes. Yeah. I can't vote, but as you have all learned, I'm a private practice here in Russia. Okay, while the audience will vote, James, I think you'd be able to announce the results of the poll in a few minutes.
Yes, yeah.
Like 1-2 minutes should be enough. Let's have a look at what are the topics that we're about to discuss today. I will start with an update with a legal update on healthcare and life sciences in Russia. And then Andrei Filipov would share his insight on a topic that is connected with personalized healthcare, a new trend and actively evolving trend globally and in Russia in particular. Next, Boris Malakhov will give an overview of IP protection in Russia, specifically related to the life sciences and healthcare industry. And at the very end, we have Christopher sharing his views on various patent SPC cases in EU and generally on the status of the industry there. So off we go. And I think when starting...
I have one question.
Yes, sure, Christopher.
From German. What is the gray zone in Russia? What is the meaning of gray zone in Russia?
Well, I think I would go into that in more detail in a few minutes.
Okay.
Gray zone is something that is not black or white. Basically, something that is not directly allowed, but not explicitly prohibited. And I think that's exactly what we have to say when we're speaking about what's happening in the legal area in Russia in a lot of industries, and pharma here is not an exception. So based on your question, Christopher, I wanted to start with the first word that comes into mind when we're speaking of the results of 2020 for pharma, and that's definitely the pandemic. Again, pharma is not an exception here. Every single sector of public and personal life has been affected by the COVID-19. But pharma appeared to be at the very brink of this new wave of social, political, etc. life. How did pharma react? we're not here to discuss the economical or business aspects of issues, but looking into the legal side, I would highlight two big topics that has happened in Russia because of the pandemic, and that was enactment of new legislation connected first with fast-track registration for drugs. That's an area that has not been that actively developing in the country for decades. And all of a sudden, for obvious reason, the regulators have decided that this is the right time for this new procedure to be enacted. So the basis for the regulation is that a drug can be launched under certain critical circumstances based on preclinical trial data only, with an obligation to run post-registration studies with special reporting and special requirements related to labeling. But still, it opens the market for a number of drugs which would have never been so fast to the public, to patients, even though it's restricted to these extraordinary circumstances that we've all appeared to be in. And needless to say that the first few products that have benefited from this process, from this simplified registration, were five drugs. Well, actually 3 drugs and 2 vaccines that have been registered, and all are related to the COVID-19 treatment. It's levolumab, favipiravir, remdesivir, and the 2 vaccines, the Sputnik, which is called Gamcovid-Vac officially in Russia, and Epivac Corona. The drugs that I've mentioned, by the end of the year, they appear to now hold a permanent registration, so they've managed to succeed in their post-registration studies, while the vaccines are still in this interim status. And that has been a relief for the market and hopefully for the patients as well. We think that's one of the positive effects of the pandemic and the way the authorities have reacted to that. The other topic that has been successfully encouraged or launched due to the pandemic situation was the online sale of drugs. It's been for years that this opportunity has been discussed on various levels, and there were different arguments, different types of opposition, both from on the market players level and from the regulators. But it appeared that the lockdown, which physically blocked patients from going outside to buy something in a pharmacy, though they might have desperately needed some treatment, have left no other choice for the regulator to establish this new business process, first as an exceptional one. In March, it was enacted through a presidential decree, but very soon in April, a new law has been adopted, which allowed online sale of OTC drugs so far as a standard business practice. Of course, I need to say that there has been place for some schemes, speaking of gray zones, Christopher, which allowed certain players to deliver drugs, and the legal argumentation they were using was quite peculiar. And as our experience suggests, regulator has not always appeared to be very rigid on fighting against those unlawful then actions. But now it's absolutely legal, and the basis for getting into the online trade is to receive a special permit, special registration from the authorities, with the main thresholds being holding that the company should be holding a license for being engaged in the sale of drugs for at least 1 year. And there's also a threshold of minimum 10 physical pharmacy units, for retail shops, retail pharmacy shops. That's a result of a compromise between the pharmaceutical industry, the regulators, and the huge online players, which are obviously looking at this sector very actively. So the solution allowed from one side to launch the online distant trade of sale of drugs, but at the same time protected the market, the pharmaceutical market, from being invaded by bigger IT giants. As I said, the online sale now relates to OTC drugs only. There is an exception for RX products that they can be sold under online under certain circumstances, again, because of the pandemic or emergency situation, but that's now only an exception. There are plans, however, that there would be further expansion of the online sale to RX drugs. Probably that's somehow connected with the launch of electronic prescriptions. And also there's been announcements earlier this year and last year that there will be some softening of these requirements of 10 physical points of sale retail shops and holding pharma license for 1 year. So that was the first word which comes into mind, the pandemic. And the other concept or situation that has struck the market last year was shortage, and it's not new to the Russian market, because the reasons lying behind the shortage were not related not only to the high demand because of the pandemic. The way the Russian government approached pricing, the way Russian government approached public procurement led eventually to some bigger players not willing to enter Russian market, shorten the supplies, or stop selling certain on-demand drugs because of that process losing its economical sense. And also, when speaking of the way the Russian government reacts to these distractions, we need to mention the so-called labeling process. Labeling, or markirovka in Russian, is an initiative that has started a few years ago, and well, simplifying things, was connected with putting a special data matrix code on the package of each and every drug sold in Russia, and establishing a special IT infrastructure where every single participant of the chain aimed at introducing the drug into the market, the producer, the distributor, the pharmaceutical, the pharmacy, the retail, should be scanning the code and reporting that to the specialized organization which is responsible for running the system. What has happened? It was due to be launched on July 1st, 2020, and despite a lot of alarmness from the market players, it has been launched, but it didn't appear to work properly. And the main problem that has been reported by the market players, that the response time from the moment you actually scan the code and receive a green light from the system was so long that it disrupted the supplies and sale on every level. There have been reports that a number of trucks are stuck in the customs at the entrance to the Russian border without being able to actually import the product since the system didn't work. And here, the Russian government did not appear to be that flexible as with the fast track registration and online sale of drugs. They stood quite hard for the entire year, and only in October some softening of these requirements has been announced, which allowed to circulate the drug without waiting for the feedback from the system, from the green light from the system. So now in February, we're at least on the producers level and distributors level, we're back to normal. And I think the industry is watching closely how the system would be working. But that's one of the ways the government has impacted on the shortage of products in Russia. Well, for other reasons that caused shortage, the government was more flexible. For instance, they have introduced a special procedure for price increase for corona-related drugs and for drugs that are expected, or like there is a risk that they would be deficient. Also, in terms of public procurement, some exception from the so-called third wheel rule has been introduced related to treatment of such diseases as leukemia and oncology. And there are also discussions that the government would be introducing a mechanism for direct acquisitions, like buying products from abroad. Well, I think I'm running out of my time, so probably I would get to the point of expectations from 2021. And I think there's lot to speak about here. One thing that comes into mind is when we're speaking of Russia and the pharma market, we always need to think of the Eurasian Union, which is a supranational institution uniting a couple of countries, including Russia, Belarus, Kazakhstan, Armenia these days. And step by step, we have more and more impact of Eurasian regulation on the market. So now we are having Eurasian registration for drugs. And after a certain waiting period, there would be only Eurasian, no national registration would be applicable. Also, there have been discussions this week about new regulations that are about to hit the pharma retail market. There is again a long-standing initiatives from the government and from, or better to say, from certain members of Russian parliament, which are willing to regulate the pharma retail in a way that would potentially or hopefully prevent its monopolizing. One of the idea is to limit the amount of bonuses which can be paid by the producers to the pharma companies, and to establish a limit, like a percentage of the market share that can be occupied by a certain retail chain. That the draft law has been adopted in the so-called first reading or first hearing this year, and we expect that it can be enacted quite soon. And probably again, as a lesson out of 2020 and expectations from 2021 is the appearance of new players in the market and development of new technologies. And when I speak about new technologies and new approaches to marketing and selling of drugs, probably what comes into mind is the so-called beyond the pill approach, when the pharma companies are realizing that it's not only the product that they're selling, but the attitude towards the patient, the way they care about the patient, apart from simply giving them a pill to cure themselves. And I think Andrei will have to say a lot about that in his presentation about personalized healthcare. Probably I would pause here a bit for another poll about gray zones that Christopher has highlighted in the very beginning of the my talk. So please use the Zoom facility to vote. And in the meantime, my question to fellow panel members, if you have any questions or comments to what I had just had to say, please ask that, by the way.
I would just briefly comment on the gray zone, which was, the question raised by Christopher. I don't think that gray here is something criminal, is something, in the shade. It's of course about the opportunities where there is no just black and white regulation.
Yeah.
Probably there is in the European Union, and you will talk about that. But I would say that the gray zone is the zone of opportunities. What I see on the market is that the competition, the level of competition is raising. The local companies try to extend and try to, win the stake, which evidently has been held by Western companies. So the Western companies try to localize, try to, override those strict regulations, like the third wheel mentioned by Andrei. So the gray zone, that's probably something which inspires, first of all, lawyers and managers to probably try something new, within the framework of the legislation. And particularly before going moving forward with Andrei's presentation, I would just mention telemedicine regulation, which is really a gray zone. Telemedicine is something which was, which started officially a few years ago, but still no one has, clear picture of how to render telemedicine services legally in Russia. So there are a few big platforms online rendering telemedicine services, but there are lots of questions towards it.
Again, quite an example of rigid approach.
Yeah, but it hasn't, bursted. No, highlighted cases or discussions toward these platforms has been raised yet, but still those opportunities, this is something which lawyers, councils, local councils, first of all, here should take care of. So Andrei, as a local counsel of an international firm working in Russia, so probably your next 10, 15 minutes.
Yeah, thank you, Andrei. Thank you, Boris. And probably before going next, also some few comments about gray zones. So again, this is the absolute value of the in-house lawyers to overcome these gray zones and to explain the opportunities and the challenges that these gray zones may entail for the business. And one more comment to James. James, could you probably share the results of the previous polls so that we also understand our audience, what are their views on these topics?
Okay, so the most recent poll, our results here, you should be able to see them. So it looks like to increase the need for risk assessment and legal advice is overwhelmingly the most popular answer there. Does that match what
the first one and the third one give actually the maximum 85%? Yeah, that gives an understanding of our audience as being quite cautious and compliant, which is good.
Does that match what you would expect to see, given the audiences? I think it was 53% in-house counsel.
Yeah.
Okay, and thank you again, Andrei, for this brief introduction. I think that you covered all basic topics and you made some perfect bridges to all the topics that we're going to discuss today. And one of those is the personalized healthcare that I want to cover here. This is really something new to the business, and for me as an in-house lawyer, that was something that I did not really expect to see in the pharmaceutical company. And here I asked James again to put the next poll to understand what's your understanding of this matter. And probably, if it is possible, I ask the audience to vote quite quickly, so that we could see the results immediately, so that I could further take it into consideration while discussing. So the question.
Text, sorry to interrupt, Andrei. There's quite a lot of text there. Do you want to just very quickly summarize the question so the audience can quickly get a sense of what you're asking?
Yeah, actually, the question is how deeply are you involved in the personalized healthcare related topics in the company? So here are the 4 answers, depending, starting from no, I do not really know what is it. I only heard somewhere about it. To the 4th, I know what is this. I work as a routine legal advisor to all these topics. And the 2nd and the 3rd is somewhere in between.
So we'll share the results quickly. So, well, by far and away, the first option there, basic understanding of what personalized healthcare is all about, and do not work with this topic in my company. That's the overwhelmingly the most popular choice. Although a quarter of people well aware of personalized healthcare.
Yeah, and actually, this illustrates what was my understanding of this topic. So I would say that the value of today's presentation would be quite big for those who have not touched this, and would also help us to find some opportunities between the companies to cooperate on this topic. So what is personalized healthcare? I will start with the brief explanation what it is, and then I will go to the key challenges and also the opportunities that this area can make for the companies, for the business, and of course for the patients. So before, I would say at the very beginning, when the medicine appeared, so the companies only developed the drugs, and the doctors were prescribing it depending on the symptoms of the patients. And then they were able to say whether it worked or not. So now the trend is to find some tailored drug to the patient, which cover not only the symptoms, but also the way of living, some genetic specifics of this patient, and to propose a very, very tailored approach to each patient. So of course, this entails some increase in R&D costs for pharmaceutical companies, but as an outcome for the patient, it is a brilliant approach. And the idea is that each patient receives the right treatment at the right time at the right value. And when we talk about the reimbursement of these medicines, this is even more important, because as of today, I would say that about 95% of treatment that is offered in the market is based on the 5% of population which took part in some clinical trials, in the actual treatment, and the doctors get the feedback from them on this. And personalized healthcare as a trend is already being supported by the government, and there is some government documents signed by Mr. Putin in Russia, who supports the development of personalized healthcare in Russia, who supports the investments into this industry and the growth of this approach. So again, it is beneficial for the government, for the budget, from the budget perspective, and also for the patients. And what personalized healthcare is about? Of course, this is about the data. So I think that during the last 10 years, we are talking about big data. Now we have a new trend. It's the real world data and real world evidence, RWD or WE. I'm sure that everyone heard something about this. And how this data, and the actual question is how this data is being collected. And some very, I would say, basic PHC elements and PHC related trends started from development of some wearable devices, from some mobile applications, which permit to analyze some specifics about the patient. But this is already an element of PHC. And today I would talk more about some even the next step in PHC, which is called the comprehensive genetic profiling. So this is actually what Josh is developing now, and the idea is here is that you can make the genetic test, which will show which treatment is more suitable for this specific patient. So actually, the doctor puts some piece of tumor, sent it for analysis to some laboratory, and then the analysis is performed. There is some feedback that is well that can be understood by the physician, and which analyze and which shows what is the best treatment. And the data that is being generated here is also important, because the results of this, let's call it service, is based on the data which is already available based on other genetic tests. So for instance, there are some patients which receive treatment with A medicine and together with B medicine, and which was good for this specific type of tumor, because we know that in oncology there are hundreds of types of tumors, of mutations, and even the most expensive drug, the more effective drug, is not always will not always work for this specific tumor. And this sort of service is provides an extra value, because there is already some sort of stratification in from genetic perspective. And oncology is perceived as one of the most holistic nosology, where such PHC related approach is already in place. But we're now talking about the different types of flu, the different types of coronavirus, and we will talk today about the vaccine. And again, this is that can be the element of the PHC when we talk about the different types of this coronavirus. And some vaccine will be applicable, some will not, and it depends. It may depend on the race, on the gender, on the way of living of the individual patient. And this was some sort of brief description. And what are the challenges? So I think I ran through them, but would like to stress one more time some key challenges which will provide some extra opportunities for the business to cooperate in favor of the patient needs and in favor of the system of healthcare in general. So the first issue, which is I think which is evident, is the legal approach to the data that is being collected through this type of approach, how this can be treated, how this data can be shared, can it be valid and trusted for all the players. So for instance, there is a service that is being provided by some specific pharmaceutical company. What can be the instruments that will permit this company to share this data with other players? Because if we talk about the oncology, there are a lot of players that propose the drugs, and the company is now, Andrei mentioned about the Beyond the Pillar approach, and this is a great example. So the companies are ready to share this data, but how the question is how this data can be validated and trusted by other partners. The next question is, what is the legal nature of these PHC services? Until recently, there was very unclear on how mobile applications shall be treated. Mobile applications related to some healthcare related instruments can be treated in Russia. Hopefully, we got the some clarifications from the healthcare authorities. But if we're talking about something more complicated, so some wearable devices, this comprehensive genomic profiling, what is that? Is that a medical service? Is it a non-medical service? Is it something that that can be treated as the companion diagnostics? So this is unclear, and this never has been available in Russia. As I mentioned, one of the key opportunities in this area is the cooperation between the different stakeholders that are involved in these processes. So these are the government, which has their purposes. These are the healthcare organizations and healthcare professionals, which need to know what are the offerings, how they can use it. Of course, these are the companies, including the competing companies. So can we talk here about some agreements between the companies, how this can be treated from the antitrust perspective, especially for there is an agreement related to the I would not say prescription of specific drugs, but the cooperation which may result in prescription of the drug of one or another company. Of course, the role of the patient organizations, patient advocacy groups. So as a center of the patient population. What is important here is the new ways of reimbursement. So one of the key issues now is the cost sharing and risk sharing agreements. So there are some views from the antitrust authority, from the health authority in Russia on why this cannot be applicable, what is required so that this mechanism is applicable. And here, again, it is one of the opportunities which can be used there to propose, for instance, some risk-sharing matters. The last but not least, and again, probably colleagues will cover it next, what if as a result of some sort of PHC-related service, a non-registered or an off-label designation of the drug is prescribed? So we have the patient, we have some sort of PHC service, and the best option for a patient is the drug that is not available in Russia for some reasons, either for regulatory reasons, while it is already available in other countries for the same reasons, or which are not available there. So what can be the options? So shall we prescribe this drug and try to put it into the territory of Russia through the available mechanisms? Or should there be some sort of fast-track registration of these drugs, provided that cannot be the only case? So this is another option. And again, as a result, being an in-house lawyer, we have to deal with all this and to propose the solutions to the business, and probably to put some items top on the agenda to discuss between the community, to share our concerns and to be united when we are proposing some solutions to the government, to the industry, and be on the same page and act in favor of the patients. So here I think I'm quite high in time, so I pass the ball to my colleagues. If you have any questions or comments, I would be happy to add something.
Excellent. Thank you very much, Andrea. I guess in the interest of time, before having the discussion, we can move on to Boris, who's going to give some comments. Boris, please.
Just a few comments about what Andrei was speaking. So he ended up with a fast-track registration, and truly congratulate Roche with their first registration of one of the most demanded orphan drugs recently. So that was very cool, and probably that was a good example of how the state was persuaded by the need of patients to get a very fast treatment of this disease, I mean SMEA drug. So that's probably one of the examples when fast track registration really worked. What do you think, Andrei?
Absolutely, absolutely, and this is again the nosology itself was very sensitive, and the patient advocacy group was very strong, and here we combined our efforts, and we made almost the impossible things, because our registration department, they worked day and night to file all the documents and to give feedbacks to the questions from the Ministry of Health on the some extra requests. So again, I think this is a great example, Boris, and an example for both for the industry that this is feasible, and also the example for the government that the business is willing to support patients.
All right, and another comment when you talked about real-life data, which came to my mind, that personal data regulation is very, very vital for these kinds of data. And just a slight comment that now the Russian personal data legislation is somehow old-fashioned in one way. So those kinds of data like genome data, apart from GDPR, where it keeps it regulated under Article 9, there is no such regulation in Russia. So no one has clear expectation of how to work with genome information under the personal data legislation. And when we talk about this kind of data, it always, it always resembles me how Mr. Weasley in Harry Potter advised Harry Potter. Just one of the rule of the wizard world is that never believes no one who can think of himself, but you cannot see where it keeps its brain. So that's probably why the localization requirement was also adopted in Russia. I mean that not just indeed Mr. Weasley works in the Russian government, but he was also a magician, a specialist in the Ministry of Magic. So probably that's the official's approach to that kind of data. When it comes to some, very, very sensitive information about patients, that information have to work under very strict regulation, and probably Russia is one of the countries among few countries worldwide where the strict localization requirement still works, and in some way it makes the work with that kind of data problematic. But many companies have solved this legal issue and now work not in gray zone, but actually complying totally with this requirement. That's my very brief comment. All right, I would proceed now with the IP part for the next 10-15 minutes. The IP regulation in the sphere of healthcare and life sciences. That's of particular significance for all the players, because actually there has been a tendency of thinking that IP, patents, trademarks, copyright, and so on and so forth simply do not work in Russia. So probably the situation has changed dramatically for over past 10 years when the Intellectual Property Court was established, new mechanism of prosecution and enforcement of patents and trademark were introduced into the legislation. So right now, Russia is among some moderate countries in terms of how the IP works here. And probably a tendency is that 10 years ago, almost no one knew how to work with IP, and the work was mainly done by outside counsels or general in-houses. But right now, every and each pharmaceutical company has a specific IP lawyer in Russia, because the landscape of this sphere is very complicated, and the significance of this one has increased for, I would say, for the past 10 years. I think that we have a chart here on IP. A poll which is gonna appear right now on the screen. Yeah, as a practitioner working in Russia or hearing something from your colleagues working in Russia, I would like you just to mark one of the options on the screen, particularly what is your approach to IP in Russia, whether it is valuable or it is, something pro forma, which you have to do, but you don't have much expectations from that. So I would just briefly elaborate on the issue of how the patents work in Russia. I mean, the patent is probably one of the most precious mechanism in the sphere of life sciences and healthcare system.
Boris, James, will you be able to put up the poll?
Yeah, I'm bringing the polls up now. Give me 1 second.
Oh yeah.
IP in Russia, there you are. You should be able to see that on your screens now.
Yeah, your approach to IP in Russia. Please vote, valuable or not. Yeah, but the patent probably is the most precious asset of a pharma company working in Russia, because patent should cover, in theory, should cover those costs which the original producer have spent for making the drug, for inventing the formula, for making this formula work and be useful for the patients. In Russia, for over the past 3 years, we have had around 20-30 disputes between originator companies and Russian generics, which used to be very aggressive and tried to take the stake of the original drug. Unfortunately, the situation is that there is no very efficient mechanism to struggle against early attempts of the generic business to come on the market when the patent is still effective. So the generic companies used to exploit this gray zone. Again, gray zone. This is the thesis which we have to use once again. The gray zone in patent prosecution and enforcement system in Russia. So a few companies, a few of them are really notorious, have evaded the market, have invaded into the market when the patents are still effective, and more than 20 lawsuits have been filed by the originator companies for the recent 3 years. The situation is that the big companies, the big pharmaceutical companies, big pharma, they are quite successful in the courts, but enforcement is really a nuisance here. So, I mean, there were a few attempts by such companies like Novartis, Pfizer, Bristol Myers to stop particular generics selling their drugs. And they won the lawsuits. They got injunctions against the companies, but the companies just still sell their drugs because the compensation are very minimum. The court decisions are really very easy to be override, but by just changing a defendant. The police mechanism doesn't work at all. The antitrust service, which also has competence to struggle against illegal sales of the drugs, is silent and probably is in support of the generic business. So it makes the patent enforcement problematic. But on the other hand, the originator companies have developed a few legal mechanisms to make their patents work in Russia. First of all, the concept of a threat of infringement appeared in Russia 4 years ago when Novartis filed a threat of infringement lawsuits against Nativa, a local company. And when considering the case, the court decided that a threat of infringement is also punishable in Russia. There is a BOLAR provision which is widespread, which is worldwide known, which says that some preparatory actions like registration of a generic shall not be construed as an infringement of the patent. But Russian courts totally supporting this view have elaborated another concept, that a BOLAR provision doesn't preclude the court to make the generic company cease preparatory actions. I mean, if the generic drug is registered, the Russian court may issue an injunction against sales of the patented drugs until the patent expires. That's very useful. But the generic companies made another strike and have filed a few compulsory license cases against original companies, under which they tried to get a license, compulsory license under quite moderate royalties to produce and sell their generic drugs in Russia. And a few attempts were successful. So right now there are a few cases when a Russian company, Nativa, bought compulsory licenses for original drugs under, again, very, very moderate compensation to the drug producer, about 2-3% of the total sales. That's very insignificant, and of course, this is not a market issue. So, and quite surprisingly, last year, at the very end of the year, on December 31, the Russian government has issued the first compulsory license on Remdesivir drug to a Russian company, Pharmasynthesis. So that was the first case when the government has raised public concern about the drug and has authorized one of the private companies to produce the drug when the patent is still effective in Russia. So those practice of compulsory licenses, to sum up, is very dangerous, and it puts much threat to the local and international players. And last year we heard that Bayer decided to freeze one of localization projects in Russia due to the fact that the generic company won a few very large public tenders, but the patent was still effective, and they never had a chance to protect the patent in the court. So right now the case is still pending in the court. It's the third or even fourth year when the case is being considered, but no one sees an end of the litigation. So it really struck Bayer's commercial interest, and they had to freeze their localization project. I don't know the current status, but that was widely announced by the company, and probably that is the factor that should be taken into consideration. And probably the final remark is that sometimes patents prosecution and enforcement landscape in Russia seems to me like a patchwork quilt, because there are some advantages to the local producers, others to the international companies, and probably Russia is among very few countries where you may quite easily get a patent for a secondary invention, you know, just like something related not to a brand new formulation, but to a method of use, a method of treatment, a dosage, a form, and etc. So this is quite comparatively easy to get a patent in Russia. It is quite easy to get this patent extended, to get a supplementary protection certificate in Russia. So, but sometimes it's very problematic to enforce it. But again, the practice has been changing step by step, and what we expect, I mean, patent professionals in Russia, is that a balance should be found, at least an attempt to find the balance should be discussed, and probably court practice gives us a stream which has to be exploited by both generic and originator business. So that's probably a piece of overview of what's going on in Russia. And again, the jurisdiction is very complicated. There are a few gray zones in how to register and enforce the patents, and each of those opportunities have to be used by business. This is what makes your business successful in Russia.
Thank you very much, Boris.
In these days of the pandemic, we talk about new developments in science and pharmaceutical industry, and especially for vaccines. And on the one side, that's a good point, because during the last years, when I'm focusing on the supplementary protection certificate, which is my favorite issue, the possibility of patent term extension for pharmaceutical patents in Europe. And during the last year, the European Court of Justice very often gave the impression that there is no need for new development of pharmaceuticals. That more or less with generic drugs you can do everything, and so maybe the pandemic is a chance to think second time about it, and especially for the supplementary protection certificates. We had a decision of the Nurem decision, and the background is when you file a request for an SPC, you have to provide a patent and marketing authorization. And marketing authorization has to be the first one for the product. So, and in the Nurem decision, the following happened. The applicant had a marketing authorization for melatonin for the use in treatment of insomnia. And he had also a patent for melatonin for the treatment of insomnia in humans. So he applied for an SPC, but the patent office did not grant an SPC because an older MA was existing, granted for the same compound, melatonin, but for sheep's animals and for the fertility treatments. So, and here the question to the European Court of Justice was, what is the first MA for this application? And the European Court of Justice decided the first marketing authorization MA, which is within the scope of the basic patent, is the first relevant MA. And here in this case, because the MA for fertility treatment of sheep's was outside the scope of the basic patent, the earlier MA had no effect. So applicant was allowed to use his new MA for the treatment of insomnia in humans. So, and here, with this decision, the European Court of Justice made it possible to grant an SPC for a new indication of well-known drugs. And for me as a pharmacist, and I worked in the basic science and in the pharma development some years ago, and I think in many cases, it's for the patients and for the health system the best situation if we have a drug which is well known, which is on the market since few or many years for different indications, and later on a new indication is developed for this drug, because you have a clear impression of the side effects of the pharmacologic profile. So, and try to imagine in the current situation, if we had a drug which is on the market for many years, and now it is discovered that this drug also can be used against corona. This would boost the treatment of corona significantly. So, okay, back to the SPCs. In the Newham decision, it has been decided, in principle, it is possible to grant an MA for a compound which has been approved for other indications before, as long as the subject matter of the earlier MA is outside the scope of the basic patent. So, and later on, in the so-called Santen decision, the European Court of Justice has decided that in principle it is not possible to grant an SPC for a new indication of a well-known drug, even if the MA, the older MA for the same compound, is outside the scope of the basic patent. And the argumentation was mainly based on the idea that it would weaken the concept of the product if different indications were allowed to become subject matter of different SPCs. So, and maybe in view of the pandemic, the European Court of Justice will think a second time about it. In principle, the European Court of Justice is a big fan of vaccines. And decisions like Medeva were in favor of the production of new vaccines, because the European Court of Justice, since many years, is of the opinion that we need more vaccines. So, I would just say a few sentences about the so-called conditional approval, what we have at the moment in the European system. Normally in a clinical study, you have the phase 1, phase 2, and phase 3. And a clinical study may take 6 years, 8, 10, 12 years. But at the moment, we don't have the time due to the pandemic. So, and since a few years, the European system offers the so-called conditional approval, which means that the applicant only has to file the results of phase 1 and phase 2. And based on these two phases, the EMA, the authorization for granting the MA, grants a conditional approval, which is valid for 1 year. And the condition is that the applicant later on files the results of phase 3 study. During the last years, we had in Europe 20 times where conditional approval has been granted, and in neither of the cases, then the approval has not been transferred to a normal approval, which means in principle this model works. And this conditional approval is For example, we have at the moment for the Pfizer-BioNTech vaccine, the end of the clinical study of the Pfizer-BioNTech vaccine will be December of 2023, which means Pfizer-BioNTech is now making the phase 3 study, and the results will be delivered later on. The conditional approval is valid for 1 year, and within this 1 year, more data have to be provided so that the conditional approval can be transferred to a regular approval. So, and I would like to say a few words.
Christopher, probably
Yeah.
I have just a brief question.
Yeah.
So that issue with the approvals in the EU, how would they influence the future of the Russian vaccine Sputnik V? So because it's now a rather challenging process in Europe for them to get their registration done. So how do you think, would the fact that the vaccine has been already registered in Russia and somewhere else in the world make something different and probably get a fast track registration for them?
During the last 2 weeks, the atmosphere around Sputnik in Europe has completely changed. And it's really astonishing to see it. I just told you about the conditional approval, what we make for Pfizer-BioNTech. Last year, when Mr. Putin said, here we have Sputnik, then the medias created the impression that Sputnik is on the market without a valid phase 3 study. But as far as I understand from my Russian friends, it has been registered last year in the summer, which is the precondition for making the clinical 3 study. And now we have the results of the clinical 3 study in the Lancet paper.
Okay.
So it's a little bit funny that on one side, Russia is criticized. It's too fast. We have no data. And at the same time, the media say, when Bill Gates talks about telescoping the studies, which means make it shorter and quicker, that's good. But as far as I understand, for the Sputnik, the phase 3 study has been completed. And
it has been, but routinely this third stage should be done before the project is registered. So the concerns were raised because the procedure has been changed, I would say, dramatically in this situation.
Yeah.
And probably that makes everyone, not only in Europe, but in Russia as well, nervous about it. But of course, the results of this stage, which has been scrutinized, really scrutinized, telescoped, like you said right now, makes feel a little bit more enthusiastic about it.
Yeah, and among the pharmacology experts I know, they share my opinion that Sputnik is a technology which has been developed over many years, and they have a lot of experiences. This vector technology for treatment of SARS or MERS. And the messenger RNA technique is a magic box. It can be a perfect thing, or it can be a terrible story. So it's that's at the moment, we don't know where the story goes. And I heard some rumors among colleagues that there are more and more problems with the Pfizer vaccine.
Oh, just not to in order not to discuss quality and brands here. So I would ask you to comment briefly on how would IP issues work with the vaccine. So the battle among the producers is it's really harsh. So
Yes.
the markets worldwide have been divided between them. So how would IP rights influence on that? So on the one hand, the vaccines usually are not patented. And now the World Health Organization recommend not to patent them at all. The technical technical manufacturing process is rather being patented. So know-how issues, trademark issues. What is your perception? Would some IP battles arise?
I think it's possible that in Germany compulsory license will be forced by the patent office. I think that's not very unlikely. That they say if there is a vaccine, but we don't have enough, we need capacities to produce them in Germany, even without the consent of the producer.
Okay. So, as I said in my part, compulsory licenses are now very common in Russia. I would have to admit it.
Yes, but as I said before, it's really astonishing that all the medias which criticized Sputnik last summer terribly now are completely excited about Sputnik. And maybe
about Russian hackers who could leave those comments. No.
And just an example that the AstraZeneca, which is a combination of AstraZeneca and Sputnik.
Okay.
For me, the Gamaleya Institute is 10 years before the Western institutes for vaccines, and they had when they developed the technology, they said, okay, let's make a primer, and after 4 weeks we make a booster. But the Russians said the booster must have a different genetic identity compared to the primer. Otherwise, if the primer works, then after 4 weeks, the body is immune against the booster. That's exactly the problem which happened for AstraZeneca, which is also a vector technology. And so AstraZeneca is a combination with Sputnik to overcome this problem.
It's interesting. Okay. Look, sorry, I'm sure everyone wants to jump in here and raise their own questions and comments. We do have a couple of questions from the audience that I can maybe put to you. So the first one comes from, I won't read his name out, but someone from Intas Pharma, which I believe is an Indian registered pharmaceutical company. He asks, how is the situation in Russia with respect to data and market exclusivity? So I think that there's a 4 and 6 year term of exclusivity, respectively. So 4 years for data, 6 years for market exclusivity on pharma patents. Is that the case? Meaning a company's following that rule? He is asking.
Oh yeah, data exclusivity regime in Russia consists of 2 parts: the commercial exclusivity and non-commercial exclusivity. The issue is that there is some legal protection, in the legislation, but practically there were a few cases, in particular one between Novartis and the local company, where the IP court has interpreted the regime of data exclusivity so narrowly that it practically has no sense for the marketing authorization holders. Apart from that, we have in our firm a few cases on data exclusivity in Kazakhstan, which is a neighboring state, and it seems to us that it is working very smoothly here. We have very positive experience, and that's what is common for all for Russia and all neighboring states. The regimes are unstable, the legal regimes of data exclusivity, and you have to analyze it carefully. So it's always a gray zone. I have to remind this term, the gray zone for application of data exclusivity.
Okay, well,
But generally it exists. It exists. And one more piece of information: Belarus was the latest country which adopted the regime just a month ago. So right now, all the Eurasian Union has been covered by the regime of data exclusivity.
okay, excellent. Well, speaking of grey zones, we have another question or comment really, but I'd be interested to get to your thoughts. And Andrei Filipov, this is possibly something you won't want to comment on, but a GC representing, I guess, an international pharma company said that, look, for international companies operating in Russia, part of the problem is that we have European style management, and that style of management views grey zones as just forbidden. It's something you don't touch. Whereas, you know, from a market point of view, I guess you could say a grey zone is a big opportunity for a company to exploit the market and develop new products and new or commercialize new things. I mean, is this what's your take on this? But perhaps I'll ask you, Boris. I mean, is there a difference between how multinational companies and Russian pharma companies approach grey zones?
I would say that this is actually the decision of the management how to approach these gray zones. So when I was submitting my application to Roche, I liked very much the line in job description to my role. So it said healthy risk appetite. So when the risk appetite is really healthy and let's call it pro-patient and pro-competitive, so why not to take this risk? So especially in any case, the risk should be assessed and the decision is made by business. And here as a lawyer, my role is just to say what could be the consequences and how and whether they may appear and what is the possibility for them to appear. But still, I would say that I cannot say for other pharmaceutical companies, but the common trend is, I think, better to use these gray zones as opportunities rather than as showstoppers.
Good. I don't know, perhaps Andrei, Boris, or Christopher, you may have a view on this.
Well, I had a comment on this topic, and also probably a question to Boris and Christopher, because I think that one of the effective approaches or efficient approaches to gray zones, and to reiterate once again, we think of gray zones as not those which are somehow forbidden by law, but cannot be touched by the regulator, as Christopher said. We understand gray zones as something that has no particular regulation at all, and it's not clear whether a norm of the law would forbid something or not. So the efficient approach that has worked in Russia, for instance, in respect to regulation of pharmaceutical advertisements, is an industry-wide approach, a sort of self-regulation when a number of associations of pharma producers would gather together, convene together with probably with their respective authority, and agree on something like a traffic lights approach, or define areas which are absolutely not touchable because of a certain consensus within the industry. And as I said, it worked. It seemed to have worked well with the ads regulation. I think there is a lot of potential to find new ways or standardized approaches towards PHC as well here, because again, this is something industry driven, and I doubt that the regulator would be fast enough to adopt anything consistent with the existing market practices anytime soon. And my question probably to Boris and Christopher, do you think there is a potential for such soft regulation, self-regulation approach in IP? Because again, it seems that at least what we see from a number of recent cases in Russia, that there is no strict policy, let's say, in Russia, that we will always protect local generic companies. It's not like that. And there is nothing to the opposite, of course, as well. What if we start building up a industrial consensus on whether something is proper or improper, and what could be the potential sanctions in this case? What's your view on that, Boris?
I'm thinking that the consent is not achievable at all because too many interests are touched. Generic companies, original companies, the government, patients, and so on and so forth, antitrust service. So I would say that the role of this institute is rather to highlight the developments in the sphere and probably some very bad practices. So, but I'm in real doubt that there is a kind of consensus between all the players. However, some companies demonstrate new trends which gonna work in the nearest future. For example, AbbVie has abandoned all its patent rights for lopinavir/ritonavir, which was being considered one of the medicines against corona at the very start of the pandemic. So they made a good gesture to abandon their patent rights to, proliferate, to make it possible for scientific society to investigate the drug against corona. So that's gonna be a new trend probably in the patent sphere for the companies who invest their reputation rather than, sitting on the patent just like a watchdog who doesn't allow to do anything with the patent. Christopher, what do you think?
My experience with the German Patent Office and the European Patent Office, that in principle they are friends of developments in the pharmaceutical field or medical field, but they are looking for arguments. And especially when you get an office action of the patent office, then I'm more and more a friend of taking the phone and just talking in a few sentences with the examiner, whether there's a chance to find an argument which could convince him. It's something like a gray zone in the patent law. It's nothing illegal, but it's not officially. The problem is, as soon as you do something in written form, then it's published in the register, so they are very strict. But as long as you just make a short phone call, then he takes the minutes of the phone call, which are part of the register, but not the real wording of the phone call. So, and I just, since a few days, I have a private inventor, and here's a spray against corona based on plants, on an extract. And he has a company for plant medicine, so he knows what he is doing. And I said to him, in principle, I think that the examiner will be very in favor of your position, because they see the need and they see that you have arguments, scientific arguments.
Interesting. Okay. Look, unfortunately, I can't bring up the survey, the polling data now, but we did have a question on one of your live voting questions, if I may. So, I think the third poll we brought up was about the approach to IP in Russia. So, nearly 50%, nearly half of the audience believes that IP is a valuable asset, but 22% said the value of IP has been deteriorating year by year. So someone has written in to ask what might be driving that trend. Is that a sign of a more general problem facing the life sciences industry with respect to the value of IP? Perhaps one of you wants to take a stab at that.
I like the figures. They show that IP work in Russia is made not in vain. But I rather see that the other answers really show that there is almost half and half. So half of the audience believe in IP, half of the audience probably, don't see the real impact of that. Probably that's a step forward comparing to what we had even a decade ago. But the work should be done, more cases, more incentives from the government, tax, advertisement and incentives to move the IP is what we really expect.
I know a few companies, one company in Hungary and 2 companies in Germany, which have more or less their focus on cooperation with Russia. And they are suffering dramatically from the sanctions. And they are just waiting for the end of sanctions, especially for scientific cooperation, cooperation for medicines. It should be stopped. Yeah.
Okay, so yeah, I mean, I guess the audience member is asking whether this is a peculiarly Russian thing. So the belief that the value of IP is going down, is that something, or do you see this in other markets, Christopher? I mean, is this a wider European view from pharmaceutical companies that IP is becoming less valuable to the industry?
No, the companies are interested more and more in Russia. Yes. They are waiting that there are more possibilities to come together and to work together.
Okay, excellent.
Yeah.
Excellent. Okay, look, do we have any final thoughts, comments from the...
James, I remember that there's been a question on reverse payment settlements and pay for delay. Someone from the audience has been asking whether there are any Russian cases on this topic. And well, Boris, correct me if I'm wrong. I think there's not been such cases so far. But given that Russian antitrust authorities does sometimes follow the pattern of European Commission and US regulators there, I think that's possible. So like if the antitrust service would identify that a certain contract has been aimed at restricting competition, that means that it might open a case and investigate and fine the parties to such contract. Yeah. Other than that, I don't think that I have any additional.
Yeah, I would just add that the reverse settlements are not regulated, but the companies really enter into settlements. And I know and I heard rumors about such settlements in Russia, so they actually exist. But the issue is that the antitrust mechanism should be evaluated. Even in the EU, Christopher, correct me if I'm wrong, they are not totally prohibited, but they are prohibited when competition suffers. So that's gonna be a very, you have to balance between pricing mechanism and monopoly still, and the balance is still under question in the EU. So in Russia, again, this is a gray zone.
Yes, and I think that the atmosphere in this issue will change in the next months due to the situation with vaccines, because now the Commission sees that the big companies are playing with them. They have the monopoly and they do what they want. And Commission will be smart enough to say, for the future, we need some different tools.
Andrei Filipov, you were going to add?
As a representative of a big company, what would you say?
Yeah, probably it's some remarks from my end. And I would say that indeed the companies are worried about the patents and the IP rights in general. However, they consider it inevitable that the life of the patent will not last the entire period of protection. And this is why they put a lot of efforts at the early stages of the patent validity to get the maximum. And this, as I said, this is not only about sales. Yeah, sure, we know that the pharmaceutical company are commercial entities, they need to get some profits, but still they invest a lot in all these beyond the pillar approaches, and they are not only selling the products. And while patents is more about selling. So they propose some extra mile to take on one hand maximum from the patent, but also to deliver to the patient the maximum value during this short period. And normally, especially the international pharmaceutical companies, they do not really believe then that the generic products will have the same efficacy, and that the generic companies in future will have the same approach to the patients. So this is the international pharma who makes the trend, and who in some areas they are the first, and that's why they use this opportunity from gray zones, and they just set up the trends.
Just one note from the patent side, that I think in the future it may be that the European Patent Office thinks more about the possibility of granting and examining faster. Just when you think normally the grant of a patent takes 3 to 5 years, a situation when we have the pandemic year, you need a much faster examination and grant of the patent. This might be an issue for the future.
Okay, excellent. Look, I guess we can wrap up there in the interest of time, in the interest of our audience, but I suppose most people watching this will have come to us through the website. I'm sure if you have any questions or need further clarification, you can reach the partners at Leidings, or indeed Dr. Christopher Brückner. I'm sure they'll be happy to take your questions by email. It should be easy to Google. So look, thank you all very much. A huge thank you to Leidings for putting this on, for such a fascinating discussion. Thank you very much to Andrei Filipov of Russia. Really great to hear a GC's perspective on this. Thank you very much for joining us. And of course to Dr. Christopher Brückner for giving us his wisdom and expertise. Thank you all very much.